As I understand it, this is something where if I have these tokens, I can let somebody have them for a while and I'll get paid something back. You determine that's a security. They've now settled that. What's the significance of their apparent admission that that is indeed a security?
Look, the significance is there's a business model in crypto whereby these, I'll call them storefronts, they're intermediaries. They ask the public and they solicit the public for their funds, their crypto, and they say, we'll give you a return. And they might call it lending. In this case, it was called staking as a service, and we'll give you 4%, 8%, or even 21% returns. Oh. And therein lies the issue. They were doing this without the proper disclosure, and the investing public gets to decide what risks they want to take. And these key questions: was Kraken or others that do this, were they taking those tokens and doing what they're saying on their website? Or are they lending them, trading against them, running other business models? And so the disclosure is critical for the investing public.
So my understanding is now Kraken can no longer do this domestically in the United States for U.S. citizens unless, I guess, they register as a security. Does that break the business model? Do you understand it? Does that mean they can't be in that business? Or can they just come back and say, okay, now we'll register, we'll make the disclosures you want?
I'll make it more generic. These storefronts, these crypto exchanges, crypto lending platforms, crypto staking as a service, they need to come into compliance, and they are generally non-compliant right now. And the investing public is not only at risk by the speculative nature of crypto, but they're at risk of ending up in line in a bankruptcy court because a lot of these platforms are doing things they're not disclosing. So to answer your question, yes, firms can come into compliance, time-tested rules, register their offerings, and properly disclose the risk and what they're doing with your funds behind the scenes. And that would be a compliant field. In this case, Kraken chose they didn't want to offer this in the U.S., and we settled.
Gary, you mentioned there are other people who are doing this. How similar are they, or is this a one-off? We had, for example, Coinbase come out right away and say, oh no, what we do is very, very different. We're not included in this. What does this mean for others such as Coinbase?
Look, it's the facts and the circumstances all matter, but generally speaking, what happens is the investing public, hundreds of thousands or millions, are transferring control and ownership of their tokens to these platforms, and the platforms are soliciting them and then saying, I'll give you a 2% return or up to 21% return. Look, this was at the middle of something that you might remember from last year, Terra Luna, and they had an anchor protocol, and it was lending. It was in the middle of Celsius and Voyager that went bankrupt. We brought a settlement with BlockFi. We've brought enforcement actions against Gemini and Genesis. That's Gemini was the Winklevi twins. So regardless of whether you call it earn, lend, staking as a service, annual percentage yield, the labels aren't what's important. It's the economics. And if the investing public is putting their hard-earned funds or crypto into a platform and getting these yields, returns, staking as a service returns, the law says they need disclosure and the companies need to register.
As you know so well, we've seen a lot of money go into various crypto devices, if I can put it that way. And we've had some lost as well in things like the scandal with FTX. Is this the first, this Kraken settlement, do you think this is the first of a series of these now? Will we pick up the cadence of the enforcement and the regulation of crypto?
Well, we've brought over 100 actions, so this may be the first related to staking as a service, but these various platforms, companies that are offering investment contracts to the public need to come into compliance. And there's time-tested ways to do that, and we stand open to work with them to do that. There are forums on our website on how to do some of this, but also the staff is ready to talk them through it. Or otherwise, you'll see other actions from our enforcement. And these are all considered and reviewed by our 5-member commission.
I'm mindful of the fact that this was a settled case. You didn't have to take this to court. That can often take, as you know, a long time to get resolved. Take a look at the Ripple situation. Is there an incentive for the next one to come in and settle instead of taking it to court? I mean, that's to say, does the price go up as the time goes on?
Well, I think it's about protecting their customers. And if they were looking out for those millions and hundreds of thousands of investors they have, they too should want to put out this proper disclosure. But here's the challenge. This is largely a non-compliant field, and they're commingling customer funds with their businesses. They're operating exchanges often. They're operating like broker-dealers, like hedge funds, often trading and market making against their customers, lending those tokens out. These are things that in the financial world, these very real conflicts, we say you have to separate out and separately register an exchange. We don't let the New York Stock Exchange also run a hedge fund and trade on the exchange. Why would we do it here?
And Mr. Chair, to what extent are you coordinating with other regulatory agencies as you try to bring, as you say, these people in compliance? To what extent are you coordinating with the OCC, with the CFTC, other regulatory agencies?
We have really good working cooperative relationships with our sibling market regulator. I was honored to chair that agency in a prior administration. We do have discussions, of course, with the Department of Justice where it's appropriate and the criminal authorities.
And is the White House kept apprised of this? Because the White House has expressed interest in this. Thhave asked the agencies to come back with recommendations. Is the White House involved at all?
Just for your listening public, we have a significant role to play as a civil law enforcement agency, and of course the Department of Justice and the criminal law enforcement. But that's not discussed at all. There's no discussions. It's independent from the White House.
And to what extent is there a risk for the banking system here? You're talking about people investing their money, perhaps not having the disclosures as required, perhaps losing their money. But to what extent is there a risk for the banking situation? And specifically, when you're asked, do you give guidance to the banks about the extent to which they should be working with crypto agencies?
Well, we work very closely with our colleagues in the banking authorities. They recently put out some guidance on this, so I'd let that speak for themselves. But I would say this is both a very speculative, volatile asset class, and it's unfortunately significantly non-compliant. We have put out guidance, the staff put out guidance about how to account for crypto, and to the extent that banks might be public companies, that there's right now often a misrepresentation of the public that these crypto tokens are the public's tokens, even when the companies take them on. And there was a recent finding in the Celsius bankruptcy where the Celsius judge said, no, you're just in line at the bankruptcy court. So we do put out guidance on the accounting for the public companies. We stand ready to continue to talk, and that, I think, helps protect the banking system as well.
Gary, you're a lawyer, I'm a lawyer. I want to protect our bar cards here, if you would.
Well, actually, I thank you for the compliment, but I went to business school and I studied economics.
Oh, that's okay. Then I have to worry about my bar card. I should have pointed out that Kraken, as I understand it, did not admit or deny allegations. That's pretty common in these settlements, and I guess they haven't really commented on it. So I didn't want to imply that they admitted to something. Although I do understand, correct me if I'm wrong, they've decided not to do any more of this staking for domestic purposes.
That's correct.
Okay, so let's go to more broadly some of the regulatory issues that we have seen, Gary, and particularly the CO2 emissions disclosure. It's gotten a lot of talk. You've gotten a little attention on Capitol Hill. I'm not sure if you've noticed that now with the Republicans in the majority in the House. Where are you on that regulation, and how concerned are you that that could get tied up in court for a good long time to come?
So we're a disclosure-based agency, and that was a debate Congress had in the 1930s. Investors get to decide on their investments. Companies make full, fair, and truthful disclosure. That's what we were just talking about in terms of crypto and this staking as a service. It equally applies to public companies now are making a significant amount of disclosure about their climate risk, some of them also around their greenhouse gas emissions that you mentioned. So we put out a proposal last spring to bring some consistency, comparability to this disclosure. We're merit neutral, but investors are already using this information to make critical decisions. And so we got about 15,000 comments. We might, after this news broadcast, get more comments. And so we're still working through those comments, thinking about, based on the economics, based upon the law, as you say, how to make any appropriate adjustments to the proposals we put out.
Mr. Chair, finally, we here on Balance of Power talk to Republican congressmen quite regularly, and your names come up more than once. They're very eager to have you up there and testify. What are you hearing from your friends up on the Hill, your Republican friends, about how much time you're going to be spending up there for oversight?
We talked to members in both the House and the Senate on both sides of the aisle, and I look forward to continuing to work with them and get their feedback and get their input. We benefit from congressional oversight, congressional input. We benefit from public input as we sort through. And our role is really to help, of course, protect investors, facilitate capital formation, those raising money in the markets, and then that which is in the middle, the markets themselves, and driving greater competition and efficiency in those markets. And of course, being a cop on the beat where we started in this discussion is not just about the crypto markets, because I know our capital markets are $100 trillion in size. Crypto is a generally non-compliant corner of our capital markets, and we need to address that and get it into compliance. But it's the overall markets that we're looking at and driving greater efficiency, promoting capital formation and protecting investors.